Good morning, everyone. My name is Peter MacArthur. I'm a partner in the Securities and Capital Markets Group of Miller Thomson. Pleased to welcome you this morning to a session that's going to be presented by Nicole Byres on labor and employment considerations for merger and acquisition transactions. By way of introduction, Nicole is a partner with Miller Thomson, where she heads up the firm's labor and employment practice group in the Vancouver office. Previously, Nicole spent nearly 14 years as in-house counsel for Tech Resources in its operations in Trail and Kimberley in British Columbia, where she was responsible for a broad range of legal matters, including employment, labor relations, and occupational health and safety matters. Since returning to private practice, Nicole has focused her practice on employment law, management side labor relations, occupational health and safety, and privacy. She was awarded Queen's Counsel in 2013. While Nicole was in-house, she was involved in a series of restructurings, mine closures, and other transactions that required the transfer or displacement of large numbers of union and non-union employees, and lengthy negotiations to effect changes to trade demarcation rules and collective agreements. That experience provided valuable insight on some of the unintended consequences of restructuring workforces, which informs her perspective and advice on the structure and implementation of mergers, acquisitions, and other restructurings. Without further ado, I'm going to turn the podium over to Nicole.
Thanks, Peter. It's my pleasure to be here this morning, and thank you for all attending. So, as Peter had indicated, this is a topic that's dear to my heart because of some of the things that I saw when I was in-house counsel, the things that you think you're dealing with all the legal issues, but as you know, managing people is not quite as simple as that, and there's always some unintended issues that pop up. And so this is a little bit of, it'll deal with the law, of course, common law, and some statutes you need to look to, and it will also deal with some of what I would call managing other risks. There is a paper that goes with there. While you have the slides today, there's also a paper that's associated with this if you want more detail. Those of you in the room have that, and online we certainly, if you haven't, if one of our capable people haven't already shown you how to get access to that, we can do that simply by letting us know. So what kind of issues can arise? It's not just the sale of assets. It can be the sale of shares where the corporate entity stays the same if the purchaser is intending to make material changes to the terms and conditions of employment of employees. And so some of these issues will apply to both types of transactions. So we're going to talk about, just as an outline of the presentation, the common law issues with respect to rights of reasonable notice, the employee's status on the sale of business, joint liability that exists in common law for severance, duty to mitigate, and then we'll talk about the Employment Standards Act and the BC Relations Code, as well as I mentioned, the managing of other risks. I'm trying to time this so that we have some time for questions if there are, either live or online. And so we'll be about an hour in total. So, starting with the common law, very basic principle, probably all aware of, but that you cannot contract out of legislative standards, so minimum standards for employment standards. You're not permitted to contract out of that. That includes in purchase and sale agreements, or the asset purchase agreements, for example. Employees are entitled to reasonable notice always, and contracts might limit that reasonable notice to something smaller than what common law might award them, but it is still a factor. And the basic factors for setting common law notice are set out there at the bottom of the slide. So we're going to talk about the presumption of continuous service, because this is an important concept both for vendors and for purchasers. And the starting point is Sorrell and Thomson, Saunders case. And the reason that this is important is it was a situation where the parties were silent. There was a a sale of assets. Actually, it was several sales of assets over the years, and Mr. Sorrell worked for this company for many years through all of the different owners of the business, and nothing was ever said about his service. And he was eventually terminated when he was fairly senior, in his early 60s, after a long service. But the new owner had only owned the business for a short period of time, less than 2 years, I believe. And the court said very clearly, this new owner, you are responsible for all of the 37 years of service that this individual has had with all the previous owners of the business. There are some variations of that case, that legal principle that's happened since then. And first of all, that there is joint and several liability for the vendor and purchaser for this severance. And the way that comes into play is that you might have a sale of assets where your purchaser has purchased the assets, they've offered employment to all of the employees, and then for some reason a short time later they've terminated. That terminated employee can sue both the vendor and the purchaser. They can also settle with the purchaser for perhaps some of the severance, and go after the vendor for the balance of what they believe they were owed in common law. And that is they're not entitled to double recovery, as particularly the Major and Phillips case, or Phillips case says, but they are entitled to go back to both. So this is, one of the practice issues is when you're doing asset purchase agreements, you're going to want to make sure you've got some indemnities. If you're the vendor and you're selling a business, and the purchaser is offered to, not only offered, but committed to recognize service for all of those new employees or the employees they're hiring, make sure you've got some indemnities in there in case the purchaser terminates them all early and doesn't do the right thing or what they should be doing in terms of severance. The Rhodes case is another BC Court of Appeal case, and the reason it's in there was it was another variation on this liability for severance. This was a government. This nursery was actually owned and operated by the provincial government, and the purchaser came in to buy the nursery. This employee had a chance to stay with the provincial government, just in a different department and different business, or accept employment with the new purchaser. They accepted, stayed with the purchaser. The nursery closed down for financial reasons about 6 months later, and Mr. Rhodes, as you can imagine, wasn't very happy because he wasn't awarded given very much by the purchaser for severance, and went after the province and won. So that's the ongoing and the liability for service, and it can be mitigated, by the way, by simply being clear with the employees. So if you're acting for a purchaser, or you are the purchaser, and you don't want to accept service, or you don't want to accept that liability for pre-closing service, as long as you're clear about that with the employees, then that will deal with that. And of course, as lawyers, we always like to see those things in writing so that it's not a fight over who said what in the circumstances. The mitigating post-closing liability. So we've got some tips in here. First of all, for the vendor, you're going to want to minimize severance liability by, first of all, inquiring as to what the purchaser intends to do with the employees. As a vendor, in the perfect world, a vendor would like the purchaser to commit to hiring all of their employees on substantially the same terms and conditions of employment as they had with the vendor. That ensures that there is continuous employment, that there are no material changes that will trigger an employee as liability for the severance. And as I mentioned already, you want to be ensure that as a vendor you're released from liability for future claims of severance. If you are, on the other hand, the purchaser and you do not want to accept liability for pre-closing service for severance purposes, you have to expressly tell the employees, as I mentioned already, And sometimes some purchasers are adamant they do not want any liability, not even the employment standards minimum liabilities. They want to trigger an actual severance of employment. I always resist against that if I'm acting for the vendor, because it seems to me it's an unnecessary cost. If these employees are continuously employed, one day they're employed by the vendor, the next day by the purchaser, for all intents and purposes their employment is deemed continuous, there's no loss to those employees. And so triggering an actual severance and paying out employment standards severance seems it's a windfall for the employees. So as a vendor, I don't want to take that cost on, but I do see that more and more from purchasers, counsel purchasers, because they're being advised about this pre-closing liability. They don't want it to, they want it to start the clock at zero again, and that becomes one of the, sometimes an interesting debate when you're negotiating the agreement. There are obligations on the part of employees also, so this concept of duty to mitigate is a very important concept, particularly if you're a vendor when you're looking at the mitigation issue or the severance issues. So this is one of the cases we refer to in the materials as Evans and Teamsters. And that was one of the Supreme Court of Canada was a pretty important case for employers, because it said even if you're terminated and you're offered another job, as long as it's material, you know, you're not being humiliated, it's not a huge demotion, you can reasonably expect to carry on your duties with dignity and respect, you're expected to take that other job. And this helps if you are doing one of these transactions. And so if you, for example, are a vendor, your purchaser has said, I'm going to hire all of your employees, but I don't want to accept the pre-closing service. So I'm going to enter into new contracts with my employees. I'm going to be clear about that. Those employees then have a choice, right? They can say, no, I'm not happy with accepting new employment because I'm losing my severance. Thank you very much. If you're a vendor, the good news about this common law principle is that while the employment standards will trigger, if they sue you for more for the common law severance, the courts will say, well, you failed to mitigate your loss. You had an offer of the same job in the same office usually after closing, and you didn't take it, and we think that's unreasonable, and you should have taken that job, and if you weren't happy with the new terms about the not recognizing the service, you could have looked for another job while you were still employed. So that works in a vendor's favor. So if you do have a purchaser, for example, who is insisting on new contracts of employment, at least for the purposes of severance, you've got that duty to mitigate that helps you out in terms of your costs going forward. The Maxwell case I threw in is just to remember, if you do have employment contracts with, and it often happens with executives, for example, you'll have some fairly significant severance terms in your agreement sometimes. There's no implied duty to mitigate if you've got a contractual right to severance. And so that's something to be a bit, something you're going to have to be aware of, where you've got a trigger. And although for employment standards purposes your employment might be considered continuous, if you've got a right in a contract that says you've got this severance obligation, there's no duty to mitigate unless it's actually written into the contract. And so that's just the point is there. I'm going to talk about some of the employment standards rules, again, that underline some of these principles. And Section 97 is the important one that talks about continuous employment. And you can see the wording there, but it talks about if all of the business or parts or a substantial part of the business is sold, and those employees have, essentially they have work one day, as I mentioned, with the vendor and then with the purchaser, their employment is deemed continuous for the purposes of the Employment Standards Act. And that means there is not the automatic triggering of severance, the severance that we would expect to pay when your employment is severed. Now, of course, if it was as easy as that, I could just stop talking, but of course, there's always some strange issues with that. But before But just to let you know, Section 97 is intended to spare vendors that unnecessary cost of severance for its individuals, employees, whether it's individuals or group on just a sale of assets particularly. There's a couple of things it's important to note that Section 97 doesn't do. It still doesn't protect you if you've got those material changes to a contract. So their employment might be continuous, but if they're taking a material drop in salary, material drop in duties, or something that would be considered material, the employee still has the consideration. You may have a triggering of a constructive dismissal, which is always a worry to deal with. I've put some information in here on group terminations because it's useful to remember if you're in a transaction where you've got 50 or more employees that might be affected, if you're going to be triggering a termination, there are extra statutory severances that get added on to the basic, and they can add up. And so I like to, Blair's heard this story already, but Section 64 is what I call the Cominco Amendment to the Employment Standards Act, because I was in-house counsel at the time, and we shut down the Kimberley mine on the day the Premier, unbeknownst to us, this is where public relations, government relations is really important to know what's going on, what your politicians are doing, but it was the same day as the Premier was announcing good news, the economy in British Columbia is fantastic, and we basically shut down a town that day. And not only did it cause a lot of embarrassment for the government, they started looking at, well, how is it possible that you can shut down this many people and have just minimum standards? And there was collective agreements involved in terms of the standards. And so this was implemented within a few months after that announcement. So whether or not it was solely as a result of what happened, I have no doubt whatsoever that was a trigger. And so it is, as you can see, you can add 8, 12, or 16 weeks on top of the 8-week minimums. And so it's notice or it's pay in lieu of notice, but it can materially affect liability if you are the vendor. Just a word about, there's a Section 65(1) that says that it exempts a vendor from individual or group termination provisions if that employee refuses an offer of reasonable employment. We used to think that applied when a vendor was buying the business. And it's very clear from later decisions now that only applies if you're the vendor and you've offered those employees alternate reasonable employment. Then there's no trigger for this. It does not help you out in a sale of a business. Now here's the part of the cases that I think were a bit worrisome a couple of years ago. It caused us as counsel to change some of our wording in the asset purchase agreements for sure. And it dealt with some pretty minor breaks in employment. So as we said a few minutes ago, Section 97 talked about continuous employment, and so if there was continuous employment, even if there was a change in the legal employer, there was, you don't trigger the employment standards. These were cases where there was a very small break. And if you are counsel doing M&A transactions, you know that there are always delays in closing. And this was an example of where there was a small break, and there's been some employment standard cases of a break of a few hours. So there was a half a day. So we used to have the things, a few years ago, if you were the vendor, you would provide notice to your employees that said, subject to closing, your employment will close at, whether it's 12:01 or p.m., a.m., whatever, on this date. We expect you will be offered employment at the next minute after by the purchaser, and that was what we were always typically doing. And this was a situation where that was the plan, but because of financing issues and various other things that came up, there actually was a gap, and people, there was a gap in employment, and the Employment Standards Tribunal has said that, look, vendor, there's a break in employment, and this Section 97 doesn't apply, and you are responsible now for the employment standards severance even though there was no loss to those employees, because you cannot contract out of the employment standards minimums, and there is no obligation to mitigate. So I talked about this obligation to mitigate that employees have to accept work. That applies in common law, but does not apply to employment standards. So, Kootenay Uniform was one of those decisions, and Nanaimo Seniors Village was another one. And so, what what we have to worry about is protecting for that kind of gap. If you want employment to be continuous, you are going to want to deal with that. And one of the ways that we've now adopted a few years ago was to say that if you're acting for the vendor and you want to put your employees on notice, you'll say that, so-and-so is buying our business. We expect it to close on this date. Your employment will be continuous. You will then be offered employment by the purchaser. If you accept employment by the purchaser, your employment with us will end. And, it really does sound like how many angels are dancing on the end of a pin type of distinction between what I described before, the old practice and this practice. But the intent is to say no matter what happens, your employment with us is continuous. And it's only terminated if you accept and start employment with the purchaser. And that's how we have been dealing with it for at least probably the last 5 years or some of the years since these decisions came out. I'm not going to talk about the statute, the Labor Relations Code, because there are some important provisions in that statute to also be aware of if you are buying or selling a business that has a bargaining unit, unionized certification for all or part of the business. There are some provisions you need to worry about. So, Section 35 of the BC Labor Relations Code is very clear. It's a successorship provision which says that if you are buying a business, even a part of a business, and even if you have your own union and your own existing business, you are going to inherit the terms and conditions of employment for those employees of the purchased business or division. You're going to inherit that collective agreement, even though you weren't a signatory to it, even though you didn't bargain it. You inherit it for the term, whatever term of that collective agreement is. So this certification right is something that follows the employees, and that is intended to be a protection for those employees who bargained that. And I've just put on the slide the Section 35, where you can see that it's talks about sold, leased, or transferred. And again, this is important to note that it can just be a piece of your business that you're purchasing or selling that this applies to. So you could be splitting the collective agreement, for example. The other thing that's important to note that and as I mentioned, if you happen to be a purchaser that has your own collective agreement and your own certification with one union, and you buy another business that's got a different certification, you then have a bunch of issues you've got to sort out as to typically you're going to want to have one bargaining agent, unless your businesses are in different locations and you can deal with them separately. But particularly when you're combining businesses, you're going to need to sort out which union represents the employees. And often even the more difficult issue than that is what's the seniority list look like? Because for anybody that has a unionized workforce, you'll know that seniority is one of the most important rights that you get as part of being a unionized member. And if you're at the top of the list for the seniority of one unit, and you're going into a unit where it's got another couple of hundred people, you're really going to be worried about where you fall on that seniority list, because it affects all kinds of things in terms of promotion and layoff and all of those things. So there are going to be those conflicts, and eventually, if you can't sort it out through negotiation with the union and the parties, the Labor Relations Board gets in and you have a hearing and they make some decisions. This Section 54 of the code is quite important, and I find that it's often it's more commonly not met than it is met, and this is the requirement to provide 60 days notice to the union of an advance sale. And the reason I say that it's often not met is because by the time you've signed a binding agreement, often your closing is shorter than 60 days from then. And you really don't want to give anybody notice that you're selling or buying a business until you've got a binding agreement in place, because you're never sure if it's going to close or not, and of all of the other unintended consequences that I'll talk about later about rumors of sales going on. So I think it's important to notice and to remember what the purpose of Section 54 is, particularly if you're not going to have time to give the union this notice. And it is, as the slide says, it's to allow the union to put measures in place to potentially mitigate any problems. So if you're a purchaser and you plan on laying off a third of the workforce at closing, that's something the union's going to really want to be involved in understanding why, and they're going to want to talk about maybe negotiating some kind of mitigation plans, etc. But if nothing is happening, so if in other words, your purchaser is going to be offering employment to all of the unionized employees, and you know their terms and conditions aren't changing because they've got the collective agreement, then in my view, if you don't have the 60 days notice, the union really doesn't have something to complain about in front of the Labor Relations Board, because there's no loss to their members. Their members aren't losing work. And so in those cases, you give the union as much notice as you can, but you'd say, look, we're closing on this date, but no, we're not the purchaser is offering employment to all of the employees, and we expect business as usual. So, and I think I'm dealing with helping out with a transaction right now where there are a large number of employees. The purchaser is buying the business for some of the technology assets and know-how, but doesn't really want to operate all the lines of business. So they know they're going to be downsizing, and this has been one of those situations where in terms of advice for the purchaser, we say, look, you've got a problem. We either have, I think this is a situation where the union's going to care if they get their 60 days notice or not. But if we can't squeeze that time in between the signing of the asset purchase agreement and closing, then, and again, if this depends on which hat you're wearing, you're probably going to want to postpone your layoffs. Don't do them at closing, and you're just going to have to deal with them after closing, because that you're going to end up talking to the union in any event. So the idea being that you should, the union's going to want its 60 days before something drastic happens to a bunch of its members and their security. I'm going to go on now and talk about managing the other risks. But before I go on, I thought I've whipped through this, some of these legal principles fairly quickly. Just wanted to see if there was any questions from the audience, either online or here on what I've said so far. Yeah, Peter.
Is there relative uniformity between the various provinces with respect to some of these rules, or are they quite different in each jurisdiction?
The common law is across Canada, although Quebec, as you know, is a civil code and is always different. And so I'm forever grateful we have a Montreal office, because I can't answer that for Quebec. But provinces, yes. And in terms of the provinces, there is an Employment Standards Act or code or something similar in all of the provinces. Most of them have those provisions in terms of continuous employment, but you want to make sure for each province, if you're dealing with multiple jurisdictions, that you have dealt with it. And if you have a situation where you've got differing provisions, you're going to have to manage. Sometimes you look for what's got the longest notice period and try to work from there. Any other questions? No? Okay. So this is a section we're going to be talking about some of lessons learned, if nothing else, in some of the deals that I've worked on, and particularly in-house. So communications is so important, and I can still remember being totally shocked at how the rumors got out about a sale, even though we were being really careful about not talking about it. And if you've ever worked in a large industrial plant, gossip is king. It's just like, gossip is really, I guess it's fun. It's something everyone engages in, and they can and small clues like having suits show up looking through files. It's usually is good for setting off a few rumors. So if you're setting out a due diligence team, or you're organizing the due diligence team, you might want to get them to dress appropriately for the operation, and maybe be as unobtrusive as possible if they're going into the operations, because those are red flags for employees. Some of the other things are just, you often when we're asking for information, if we're doing due diligence, we need to engage sometimes people from your finance department and your engineering department, depending on the company. So you're going to want to plan ahead of time, particularly as your in-house counsel, is who are the people that are going to be the point people for the due diligence. Impress on them the importance of keeping it quiet. It is not, it's for the well-being both of the employees and for the business that they are. And, that includes not talking to your spouse, especially if you're in a small town, about what's going on. It's just so easy for word to get out. And, in the worst case, distracted employees have accidents, and that's the bad thing. And you don't want distracted employees. You don't want your safety to have safety issues. But it can also affect productivity. Can you imagine if your core value is client or customer service, and you're worried about losing your job? Maybe you're not going to be returning that customer or client's call so quickly. Or maybe your service isn't going to be so great because you're on your mind, you're wondering if you've got a job. Those are some of the things that those are real effects on your business. You all of a sudden start losing your customers, for example. The other thing, I talk about employee retention. Good employees have options. And if they're worried, they hear a rumor about a sale and nobody's talking to them about what it means for them because, it's not supposed to be announced yet, but they have the worry without the information, they may just take that offer that's been out there from a competitor or something else. And so the people that have options will go walk with their feet. The people that may not have options, or what sometimes I call the problem children employees, may be worried about their jobs and all of a sudden have a disability claim where they're off in that sort of limbo, as of having a claim, but thereby preserving income for a while. And I think, finally, there are other, I'll talk about some of the things that I know IAS will deal with in terms of IP loss, but certainly with people walk out the door that are your key people, and whether or not it's protected IP or just the know-how, that's a real loss to your company. There's also been some statistics. Been a study that employees who know of a pending sale coming or worried about it and nobody's talking to them about benefits, they will all use up all the benefits they can. So, all the children get sent for their teeth to be, whatever they can do to max out the existing benefits, because they think there's a sale coming and they're not sure if their benefits are going to be carried on. So, couple things to think about on that. If you're the vendor and don't want your claims costs to go up through the roof, you're going to want to maybe assure your employees not only of continued employment, but what you can tell them about benefits. And just a final note, for those of you acting for companies that are regulated on stock exchanges, you have rules about when you can announce material events in a company, and those all complicate some of the things I've just been talking about, because you've got even stricter regulations on that. I've already mentioned benefit costs that can go into for rumors of sales, but in terms of the non-communications issues, you want to be really careful there's no gaps in coverage. And that's sometimes if particularly you've got a purchaser who's new to the country, they'll be setting up benefits for the first time, and maybe they're setting up a new benefit where there's no choice, but there's waiting periods, for example, for employees. Even though they're taking over existing employees, they've got a different plan. I've been in situations where we've negotiated with a vendor to have them carry the employees on their benefits. The purchaser pays for this, of course, but it's just a way to ensure there's no gaps in coverage for some of those important medical expenses. The other thing is you don't want any unintended gaps in insurance. So life insurance in particular, I'm aware of a situation where there was accidental drop in, there's changes in benefit carriers. The life insurance wasn't put into effect, and we had an employee die of a heart attack, found out that there's no life insurance in place. Those are situations where you can have a large, it sounds like it's a remote occurrence, but when it happens, the cost can be quite significant. And you don't want to be the vendor and the purchaser who are now dealing with claims by a bereaved family because there are no life insurance benefits in place. One of the things that is an issue, of course, is, and these go for closing adjustments, are on vacation. So employees, as you know, will accrue vacation and sometimes are quite often at closing, they will have accrued but unused vacation. And I know that, first reaction of a purchaser is to say, I'd like a clean slate, vendor, pay out all the vacation, and I want to start over. And as a labor and employment lawyer, I'm not a big fan of that. I would just assume that those liabilities were assumed by the purchaser, and the vendor pays the purchaser for the cost of that, because you want your employees to have vacation. Usually if they've been working almost a year and you've just now paid them out, they're still not getting the rest that you'd like them to have. It can certainly make an unhappy employee if they've got some plans for the summer and you've just now told them that you've been paid out in your vacation, you can't take it. If I was the purchaser and going to be trying to set up a new relationship with my employees, I just would like to make the transition as seamless as possible. And so as a purchaser, to me, I think it seems like such an easy concession. Is the vendor's going to pay for it anyway. So get those costs of accrued liability as one of your closing adjustments and let the employees take their vacations in the normal course. I had a lot of conversations with parties on that because they're looking at it from an accounting perspective usually. We've got lawyers and accountants and the business people, and sometimes the human resources people just aren't there to say, hey guys, what about a whole bunch of unhappy employees. So it's important. Pension plans, if you are, there are not a lot of defined benefit pension plans around anymore unless you're in government or some very large companies, but even the large companies have phased these out for new employees. But those are complex. We have lots of rules and statutes on defined benefit plans, and you're going to require specialized advice if you've got some of those transitioning. But both defined benefit and defined contribution plans will need some type of transition of advice if you're dealing with that. Employees on leave, it's one of those hidden issues. If you are a purchaser, you're going to want to know who's on the rolls but not at work. What are they on a parental or maternity leave? Are they on some disability leave? You're going to want to know who those people are and come to terms with what's going to happen in terms of employing those people, because the last thing you want is somebody to show up 8 months after closing saying, hey, I used to work in there and I was just off on leave and I'm ready to come to work now. So deal with those up front, and that's always needs to be part of the disclosure and the due diligence. There are privacy issues. We all know, most employees now know about privacy and their rights. The privacy legislation's been around in BC for at least, it's more than 10 years now, but across Canada we've had various both federal and provincial forms of privacy legislation, both for private sector companies as well as public sector. And employees are very aware of their rights, and they're very sensitive. And so where you may not have paid much attention to this as counsel when on doing deals, I would always make sure that your agreements have provisions where the purchaser, if they're getting all of this personal information of their employees, you've got some protections on privacy in the sense that they're getting, they have systems in place to protect the information. If the deal doesn't close for any reason, this information is going to be returned, and you've got some obligations on those purchasers and covenants that go with that personal information. So that you as a vendor, because you're the ones giving it out, and there are reasons why you can give it out, but you've got some obligations to ensure that how you do that, there are protections in place. I just made a note also that I usually put that's part of the, if you're at a letter of intent stage on a deal, that's usually the privacy provisions, is I would put them in there, and those are one of those obligations that carry on whether or not the deal closes in terms of privacy. Again, in the category of managing risks, we've got the issue of retention of staff. As I mentioned before, people with options will leave and sometimes it's really important to the vendor or the purchaser that your key folks stick around, whether it's till closing or if you're buying the business after closing. And there are ways to deal with that. We have retention agreements, for example, that can be entered into with those key employees, but and sometimes there will be things like change of control provisions. You may have, particularly for publicly traded companies, you'll have change of control, and the idea is you want to put those in place early on before there's a transaction, because you can't. It's very difficult to negotiate these extra bonuses for change of control if you know you're going to have a change of control short time. There's some obvious issues with that, but you want to think about those really early on in the deal. And there's also some timing issues with that. I think it's important to realize that the purchasers who want, for example, some key star employees to come over, they're going to want to start talking to those key employees right away. But if you're the vendor and you don't have a binding sale agreement yet, the last thing you want is some people talking to your star employees about coming over. And so there's always this bit of tension between, I'm not going to let you talk to my key employees until we have a binding agreement, but if you're a purchaser, you might, and you don't have that gap between the signing of the agreement and closing, it may be too late. And so there's a delicate dance that goes on there. And all I can say is that you have to consider what the delays. I mean, if you're a vendor, the easy thing to say is you cannot talk to any of my key employees until we've signed a deal. The challenge with that is if you've just spent 1 year or 8 months negotiating all the terms to a very complex deal, and you get it signed but closing is only 30 days later. If I was that key employee, think of the leverage you've got now that your company has just spent a couple of $1 million or whatever in due diligence and negotiating a deal. You can pretty much ask for what you think. You can ask everybody for what you want, and so there's that leverage also. So a lot of moving parts, I guess I would say, in thinking about that. Yeah, I just talked about this slide. So some deals will require vendors, key or principals to stay on for a period of time after closing. And I would have to say that as a rule, vendors always underestimate how hard it's going to be to stay on in what was their business when somebody else owns it or calling the shots. And even if they're not in Vancouver or in the town, there's somebody else is exercising control. And those people find that very difficult. So if you are acting for a vendor, and part of the deal is the principals are going to be carrying on, and I appreciate that they're going to be getting independent advice at some point on their employment contracts, but something that you need to be considering is you want to, put as few ties on, if you're the vendor, you want as few ties on those principals staying on for a long time as possible. And I know there will be delayed, earn-ins and earn-outs and all those things in terms of delaying your the price of the sale of the business. That will be part of that. But you might want to just think about, don't commit your principal to 2 years, perhaps, if things don't work out. So, as I mentioned, you want to limit lengthy business payout clauses. And if you're the purchaser, it's really important to clearly outline the deliverables you want from these people. So if you're bringing the vendors or the principals on and you've got some specific things you want them to do, then make that a part of their employment contract. As opposed to length of time that you're here, maybe you just want those deliverables because you just might find the relationship is too hard to carry on. But if they've delivered the things you want, it may not be an issue. So those are just some ideas about thinking about what happens on the post-closing. So preservation and protection of intellectual property. There was a CLE a few weeks ago that talked about getting your business ready for a sale. And that is because some of these things that make it your business more saleable, such as having good employment agreements and having good agreements protecting your IP, for example, if you're a technology firm, you can't just put those in place as you're selling the business. There's some time required to put that in place. So, but it's surprising to me that companies or businesses will try to they'll sell their business or they'll put their business and get a seller, or a purchaser interested, and they haven't done some of that due diligence. And if IP and know-how is a key component of what you're buying as a purchaser, you want to make sure that that's nailed down. And so there's you're going to want to confirm as a purchaser that there were agreements in place, or at least policies, and employees understand their obligations, or at least start getting that messaging through. I have seen situations where a company purchased a high technology company. They didn't pay attention to the human beings, I would call it the human part, the human resources piece of that, didn't delve into fact, just discovered they had no employment agreements. They had not signed any type of agreements on ownership of IP and confidentiality. And even though there were common law obligations of confidentiality, those employees didn't understand it, walked out the door with all kinds of things in their head. And the value of what the purchaser got in the end was much less than what they thought they were paying for. And so, again, if you're involved in a purchaser's sale of your business and part of it has got some IP associated with it, best to get somebody looking in right away to see what's in place. Both if you're a vendor for value, to make sure you could actually sell what you say you're selling, and if you're a purchaser, that you're going to get to buy what you think you're buying. And finally, I'll just say restrictive covenants. There are lots of cases about enforceability of restrictive covenants, but I want to make a distinction between restrictive covenants in the sale of a business versus restrictive covenants in employment situations. So it's increasingly difficult to enforce what I call the employment restrictive covenants, where the employee has no bargaining power and they come in and say, we're going to restrict you from what you can do after we let you go. That's a restraint of trade. Courts don't like it. Non-solicitation are much easier to enforce. Restrictive covenants are very, very difficult. We are watching the cases month by month, and injunctions are pretty much impossible to get now for restrictive covenant breaches, so that you know. However, sale of business is a different story. The vendor is getting a lot of money usually for the sale of their business. There's real consideration. There's much more of an equal bargaining position. And so it is quite reasonable, if you're buying the goodwill of a business, that your vendor doesn't go out and set up the same business next door to compete with what he or she has just sold. So the courts have said that restrictive covenants in that context are still enforceable. 5 years is typically still the maximum for purchase and sale of businesses. But you still are subject to a reasonableness test. That means in territorial and time, length of time and territory, they have to be reasonable. So if you're buying an equipment rental business that operates in British Columbia and you want to restrict somebody, an owner, from setting up a business anywhere in Canada, it's probably unreasonable. Western Canada might make sense, or the Pacific Northwest might make sense, depending on the type of business, but you've got to look at what you're buying and match that somewhat to the type of condition that you want for someone. So just in summary, I guess from my perspective, and I'm biased, but labor and employment considerations can be a very important and material consideration in the buying and selling of a business. It is extremely important to pay attention to these issues, at least from a strategy perspective, early on, even before you sign an LOI, in my view, because I've seen LOIs where the parties have committed to certain things about whether or not the purchaser is going to offer employment. And I've I call it entering a deal, but being asked to provide advice on a deal after a signed binding agreement, for example, where the vendor has agreed to terminate all of their senior employees, because this was a merger of a smaller business with a bunch of other businesses, and they had all the management staff they needed. They had a $500,000 severance cost. They had no idea about that kind of cost, and that was a material chunk of the price that they were receiving. It was about 25% of the value of the business. It's a big hit. And so it's just a simple example of those kinds of things that maybe a purchaser will want ahead of time. It has a material effect on the costs. So I guess, and last but not least, some of these unintended consequences, thinking about the people side, particularly you're in-house counsel, and you will live longer with the deal than us external counsel will. And if things don't go well on the employee side, you're probably going to hear about it, if not wear it. And I think it's good to be thinking about these things, at least to advise management about your perspective on some of these things, because particularly if you're the purchaser, you want to be successful with that new business. You want to get the loyalty and support and the best efforts of those employees, and that there's lots of little decisions along the way that can affect that. Again, if you're the vendor, similarly, there are things that can cost you money you may not have been aware of, or in terms of things, for example, on the IP I just mentioned. And so, again, deals can go wrong for things that may not be the most important issue of the day when the transaction was negotiated, but they end up being material because of the human resources implications of that. And so you want to avoid that. I mean, that's, from my perspective, part of the fun part of being in-house counsel is you get a chance to get in on situations and deals to direct a better outcome than might otherwise have happened if they hadn't talked to you beforehand. And you have a chance to add real value at the front end from a senior management point of view. And so these are some of those issues that you can ask questions about and get involved in earlier that will, I think, if you haven't already demonstrated your terrific value to the organization, this is definitely one of those areas of opportunity. So that said, I think I am 5 minutes to, and I've got a few minutes for more questions if anyone has some. Peter. Thank goodness for Peter answering questions.
In a public company setting, you're quite right. Typically, there's an announcement much earlier in the process by virtue of regulatory requirements. So we like to negotiate retention agreements, because if it's obvious the organization's people are not going to be kept on after, they start to look, and they'll get out earlier than we would like. So we negotiate retention agreements with them, which might involve bonuses and that type of thing to keep them in the organization. Do you see retention agreements with private corporations as much, or what's the story there?
Yeah, you can still see them, particularly where you're you'll have a company where maybe it's been built up by a certain team, or you've got key members from, whether it's because of their technology skills or they're the inventor, they're the genius behind the new brand of cookie that is being sold. Sometimes you really want those people to be kept on. And so, yes, I've seen them in private sector organizations also. Again, there's always this balance about when you talk to them and when you get them involved in that. But they tend to be those, they're the high value folks in the company that you would really want to keep happy if you're the purchaser going on, or if you're even the vendor. So, okay. Any other questions? Yes.
I have a question on that Rhodes case that you referred to earlier.
Yeah.
So I'm just wondering why there would have been liability to either the vendor or purchaser if the employee was offered and refused employment with the vendor.
Because there was no, when the employee accepted the employment with the purchaser, there was no contract. They were absolutely silent on the issue of what happened to the pre-closing service. So the court said, even though they were offered and refused employment, nobody dealt with, by the way, Mr. Employee, you're not going to, or Mr. Rhodes, you're not going to, we're not going to recognize your service. So because they were silent on that, they said that Mr. Rhodes got all of his pre-closing service, and the principles of the joint liability then kicked in. So the province, who had offered the job and refused, were also on the hook. And because the purchaser had gone bankrupt, they were the ones that ended up paying for the bulk of the cost. So,
had they had the proper documentation, it would have been.
Yeah.
Okay.
Yeah, and it can. There are some decisions, and the courts will say, even a clear statement to the employees, we will not recognize. If it's an email or a memo, if you haven't got a contract, that also works, as long as before the employee accepts the employment, they're aware of that. You can't, after the fact, change the rules, of course, but that's the issue. The fellow that was one of the co-authors of the paper that goes with this presentation just finished a trial where he was acting for the individual who was let go, and the vendor entered into a retention agreement with him, offered him, because they had been laying off and wanted this key employee to be there right through to closing, and offered him a large bonus retention agreement. He was then accepted employment with the new purchaser. New purchaser let him go after a couple of months. No contract in place. Again, and the vendor tried to say, well, we paid this person a retention agreement to stay, and the court said it was a retention agreement. The consideration was for the work up till closing, or to stay until closing. It was not. Nowhere did anyone talk about we're not recognizing your service. So you got joint liability again for the full severance for this individual, even though he'd only been a few months with the purchaser. So they're different concepts, although they intuitively, like you said, you would think they were the same. We've had lawsuits on these just because other lawyers thought exactly the way that you did, and the BC Court of Appeals said they're not going to accept that. Any other questions? Okay, well, thank you again for your attention. And I'm happy to answer any questions if something comes up after the fact. I think you can find my contact information pretty easily on the website. So happy to take a call, happy to take an email if something occurs after. Thank you.
Thank you, Nicole. So I'd like to take this opportunity to thank Nicole for her informative presentation, and I know that I should run down to your office and see you the moment I get an acquisition deal or a sale deal in. Thank you everyone for attending in person and over the web, greatly appreciated. This session will qualify for 1 hour of CPD credit, and all you need to do is go to the Law Society website, scroll down to the provider, Miller Thomson, and I've been assured that it should be there. Our next session, for those of you who want to put it into their calendar, is scheduled for September 17th, entitled Managing and Protecting Intellectual Assets. and it'll be presented by my partner, Ayaz Alibi. So with that, I'd like to say that concludes the session. Have a great day. Thank you.